Yes, and I've got David Daley joining me to talk about the very important and ominous argument that was heard today at the Supreme Court. They heard an argument about a redistricting case that could undercut the Voting Rights Act, which is very, very serious. It's a very important issue, and there's nobody better to talk to than the gentleman you see on your screen if you're watching, and welcome to those watching live. Senior fellow at Fair Vote, the author, the national bestseller, Rat Fucked, Why Your Vote Doesn't Count, and Unrigged, How Americans Are Battling Back to Save Democracy. He is a real expert, and I am very happy to have access to your expertise. Thank you for joining me, David.
Always a pleasure, Pete. Thanks for having me on.
I'm guessing you watched or you listened. You can't watch to the arguments today.
I did. I listened in, and I think ominous is the right word, but ominous, but also sort of sadly expected, right? I mean, whittling away at the Voting Rights Act has been John Roberts' life's work. I mean, imagine getting up every day since August of 1981 and deciding that that's going to be what you're going to work on. But I mean, John Roberts has, for the last almost 45 years, pursued this purpose with solid intensity. And what he could not win as a young aide at the Reagan White House, as he sort of fought against the reauthorization of the VRA back in 1982, he now stands in position to achieve as Chief Justice of the Supreme Court.
It's crazy. The headlines are terrible. It looks like the Voting Rights Act is doomed. The Republican justices hunt for a reason to gut America's most successful civil rights law is one headline by Ian Millhauser, who knows his stuff over there at Vox. And, this is just really sad and upsetting because of what it took to get the Voting Rights Act, and more importantly, why we needed the Voting Rights Act, and literally how many people died trying to pass the Voting Rights Act. I guess the argument in very, very short is, well, it's no longer needed.
The funny thing about these arguments that it's no longer needed, it always seems to come in cases that prove how desperately it's still needed, right? I mean, this case wouldn't be before the court right now if Louisiana had not, essentially attempted to do a racial gerrymander of its map. The Alabama case, Milligan, right, would not have been before the court but for Republican lawmakers in Alabama's determination to maximize every seat that they can. The Shelby County case that took the first whack at the VRA back in 2013, that John Roberts used to argue that things had changed in the South and that this was no longer needed, that preclearance, the most important enforcement mechanism of, indeed, the most important and successful civil rights legislation the country's ever seen, the civil rights legislation that made the idea of multiracial democracy real in this country, really for the first time in 1965. And, that case itself, based on an Alabama town that redistricted its first Black councilman in years out of office, and based this on 175 annexations, none of which had been pre-cleared. And this is what John Roberts uses to say, do we really even need that anymore? So these guys are wrong on the history, that they're wrong on the facts, but they have six, and that is what it takes. You change the court, you change the laws, and Republicans and the conservatives understood this, and they have gone to work to, make it so. That was, in many ways, the key lesson that John Roberts learned from his first assault on the Voting Rights Act back in 82, was that you don't need the White House, you don't need 51 senators, you don't need 218 members of the House if you can count to 5 on the U.S. Supreme Court. And now that they can count to 6, all bets are off.
Let's talk a little bit about the history of why it was needed. I've got one brief summary over at the Brennan Center, which says the law was a more fulsome response than prior inadequate efforts to assure that states registered citizens allowed them to vote regardless of race. Despite multiple court orders, including the Supreme Court, several states created rules that denied or limited opportunities to vote for black citizens, such as poll taxes, literacy tests. These schemes effectively undermined or eliminated the political power of black communities, even where they were a majority of the population. We could talk about the effect of the Voting Rights Act, but what more do you want to say about why it was needed, why it was necessary?
Well, it was needed because of stubborn resistance across much of the country, but especially in the South. Congress had tried, the Reconstruction amendments to the U.S. Constitution are passed after the Civil War, the 13th, 14th, and 15th Amendments. And those should have been enough, right? But they were not enough, in part because in a series of cases, the U.S. Supreme Court said what John Roberts is saying right now, that we don't still need this. The court, even in the early 1870s, was saying, well, it's been 7 years since the end of the Civil War. Why do we still need these special protections? And in the Civil Rights Act cases, and a handful of others back then, began to remove the federal protections, and they left it up to the states which had absolutely no interest of enforcing this. And indeed, we got 75, 80 years of Jim Crow prior to the Voting Rights Act being passed in 1965. But even in the years leading up to the Voting Rights Act, Congress had tried with, various versions of the Civil Rights Act in the late 1950s and the early 1960s. None of it worked because you needed federal enforcement. Congress would pass a law or a federal court would do something, but the local sheriffs on the ground didn't care. Or the politicians would find a way around it, a clever way to come up with a different sort of poll tax. And right. This would push people back into court to challenge that. So the entire idea of preclearance was to say, we've been trying to do this nice for years and you keep finding a way around it. So now you can't do anything unless we approve it first. And John Roberts got rid of that back in 2013. In the Shelby County case. But he was clever about how he did it, right? He didn't actually say we don't have preclearance anymore. He simply froze the very technical formula that was used to determine which states were under its thumb. And I imagine that's what we're going to see out of this court now. They will pretend that the Voting Rights Act still exists. It will just be neutered in such a way that it can't actually do anything or protect anybody.
It's weird when they make these decisions, this court, the Roberts court, and the day they say, well, we don't need this law anymore, or this isn't happening, or this isn't a concern, then in real life, it immediately becomes a concern. For example, when they repealed Section 2, immediately, I forget which state it was, Texas passed a law that was straight racist and limited voting rights, and other states as well. The other couple weeks ago, the Supreme Court, was this a shadow docket, when they basically got rid of around somehow the Fourth Amendment, which allows law enforcement to arrest people, judge people based on the color of their skin. And they said, this isn't going to be an issue. We're not worried about it. Of course, immediately it was an issue. So it's like at the court and during the arguments or in their decisions, which if they come in the shadow docket, apparently pretty limited, but even in these arguments, they act like a thing is obsolete, and they make the ruling in June or whenever it might be, and then immediately the problem they're saying doesn't matter happens. How did I do in a layman's term of what happens here?
You got it exactly right. I mean, Texas, you can't say things have changed in the South when states have prepared voter suppression laws in advance, waiting for you to say that things have changed, and then enact them an hour later. Texas had this voter ID bill that you're talking about ready to go. So did Arizona. These states were primed and ready. And the second that the Supreme Court said, we don't need this, they showed why it was. But, this was covered in newspapers before the court made its ruling. They could have, all of which suggests that maybe the court has a different agenda, that maybe the court has a political agenda that is not attached to actually describing reality on
That
the
is not
ground.
how our friend Siegel would put it.
Allow me to suggest, allow me to channel Eric Siegel. The court is not a court. The court is a super legislature of 9 appointed for life. Given
politicians in robes is
politicians in robes. Yeah. And they ought to be wearing red and blue robes, and they ought to be wearing the, like race car drivers, they ought to have the patches of whoever sends them on vacation on whose super yacht, which billionaire is paying the education bills for their friends' kids, or who's buying their mom's house, or sending them salmon fishing, or funding their European vacations. I mean, let's be honest about what's happening here.
Yeah. There should be maybe not lifetime tenure. Maybe if they were going to wear a uniform that more represented their beliefs, maybe Alito would just dress as a corrupt priest. I don't know how that Halloween costume would be made, but so
I mean, they're already in robes.
It's crazy, this argument today. It's so consequential. There's a flood of news every day. I'm so glad that you reached out to me to let me know that you were available to talk about this, because we have to talk about this. There's so much happening, but the Supreme Court is always in my mind one of the most important places. And when there's arguments that are so consequential like today's, this case is Louisiana versus Calais. Is it French or something? A French like town in Louisiana.
Yeah. No, it's extraordinarily consequential, and it's consequential for minority representation across the South, and it's consequential to everybody in the nation because of the partisan political implications, right?
Black folks overwhelmingly vote for Democrats. Historically, young people overwhelmingly vote for Democrats. So Republicans for years have tried to make it harder for likely voters who are likely to vote for Democrats to vote. They've made it as hard as they possibly can everywhere they can, but it's easiest to do, one might argue, based on race, because you can see them and you can see where they live and what districts they're in. And even in majority minority districts, we thought in Louisiana they were going to be representative and uphold democracy, but apparently not.
That's right. I mean, the backdrop for all of this, right, is that Republicans hold the House 219, 216, 3 seats that tip the balance of power. And, Democrats have been pointed toward next year's midterms, believing that the House is one way to claw back some say and some check on what has become an increasingly authoritarian Republican Party in Washington and in these states. And yet what we have seen this summer, right, and into the fall, are 2 different tracks. We've seen the partisan gerrymandering track, in which the president calls Texas and then Missouri, Indiana, Ohio, now North Carolina and Kansas, Florida, and says, do a mid-decade redistricting, gerrymander me more seats so that it is easier for Republicans to hold on to power. And so they do the 5 in Texas, 1 in Missouri. There's going to be 2 or 3 coming out of Ohio. North Carolina today has announced that it's going to move on this in the next couple of weeks. Kansas is working on it. Ron DeSantis in Florida is eyeing somewhere between 3 and 5 seats. There's about a dozen seats that Republicans could grab through partisan gerrymandering. And that's even if California goes ahead and counteracts Texas. Now, the partisan implications of Calais, if this case is decided the way we think it will be, and if it's decided soon enough for Republicans to draw new maps, is that it will liberate these states across the South: Alabama, Louisiana, Mississippi, Texas, Florida, North Carolina, Georgia. It will liberate all of them to go back and wipe as many black districts as they can off the map, and to replace them by districts that are won by white conservative Republicans. If you add together the dozen seats that Republicans could get post-Calais with the 10 to 12 seats they could get through partisan gerrymandering right now, add that onto the 3 seats that they already have power control of the House by, that begins to be an almost impossible road. You're talking about 24 seats. Where are you going to find 24 seats in this country that are competitive and flexible?
One would look to California and other states to see if they can keep up and catch up, but that doesn't solve for this argument that we heard and what that would mean. Right. So just what's the timeline of when this decision could be announced and when states could react and gerrymander further or rewrite these districts? Is that timeline coincide or before the midterm elections? Is it quite possible that all this can happen?
It's a great question, and I think it will. It all depends on the timing of when they hand this decision down. Now, the court usually hands down its decisions in June, right? There's those days in June where they unload all the big cases. But there's no reason that they have to wait that long. They could just as easily hand this decision down in January or February. If they wait until June, it might be too late for these states to go ahead and remap.
We wouldn't be surprised if, for political reasons, they announced it early or even unorthodoxly early, because what they did at the end of 2 terms ago, when they took so long to announce the decision about whether or not we can have a king. What was that case? The power that he basically can't he can commit any crime he wants. Like that decision was announced at the very end. They dragged that out, and that was the simplest case. It was a overwhelming and unanimous decided at lower courts, yet they waited till the last minute to weigh in on that. So it wouldn't be surprising for them to politically upend their normal schedule.
I mean, let's face it. And I'm channeling Dr. Siegel again, right?
Yes.
But, the entire goal here is Republican political power. The Supreme Court has become the highest bastion, the true source of Republican political power. And its rulings in all of these democracy cases over the last 15 years, from Citizens United through Shelby County on to the Rucho case that enabled all of these partisan gerrymanders nationwide, through the Brnovich case from Arizona that took the first whack at Section 2, onto Calais today. All of them have tipped the scales in one direction, leaving us a country very much at the doorstep of one-party minority rule.
Very much at the doorstep of one-party minority rule. Let me try to play a clip on this live stream that I'm doing with you. I wonder if I can do it. I've got a clip of oral arguments today, audio, obviously, no video. This is the Louisiana Solicitor General, Benjamin Aguinaga, which sadly is a man of color arguing against Voting Rights Act here, which is not lost on me. But anyway, he's arguing with, of course, Black woman Justice Ketanji Brown Jackson in this clip. Let's see if I can get it to play, David. There's the audio, of course. Here we go.
Well, Justice Jackson, I think there's a reason why this court's voting precedents, going all the way back to Shaw 1, are so tied up with race. It's because the remedy, as parties and the courts have understood Section 2 to operate, is almost always going to be race-based.
They're so tied up with race because that's the initial problem, right? That's the beginning. The beginning is the claim that a person makes under Section 2 that because of their race, they are not being afforded equal electoral opportunity. It is a separate question as to how we go about remedying that and the extent to which we need to use race as a remedy. That's the question we're here on today, but the Section 2 issue is just what circumstances do we look at to determine whether this problem of unequal electoral opportunity on the basis of race is occurring.
Right, and a couple of responses to that, Justice Jackson.
Wait, so can I just ask, why is that not a compelling state interest to identify areas in which that problem is occurring?
Your Honor, of course, as this court recognized in SFFA, states can remedy intentional
No, I'm not talking about the remedy. I'm talking about
identify.
Identify.
Of course.
All right, so if I'm right, that Section 2 is about identifying the problem and then requiring some remedy. I don't understand why your answer to Justice Kagan's question about is this a compelling state interest is no. The answer is obviously yes, that you have an interest in remedying the effects of racial discrimination that we identify using this tool. Whether you go too far in your remedy is another issue, right?
Your Honor, I think step zero in all of these cases, it was certainly step zero in the Robinson litigation, is the plaintiffs came in and said, we want another majority black district.
I thought they came in and said, we are not receiving equal electoral opportunity because our votes are being diluted.
Which is the same way of saying we deserve a second
No,
majority
it's not,
black district.
because again, just trust me on this. The second electoral or second district is a remedy that one could offer for a problem that we've identified. And the whole Robinson litigation was about identifying the problem. Is this really happening? In many, many Section 2 cases, the court says, you're wrong, you're fine. There is not an electoral opportunity being denied to you, go away. In this case, the court said, I see. I'm looking at the factors. I appreciate what you're saying. You've proven that we have this problem. And so the next question is, how do we go about remedying it?
Right. And the problem, Justice Jackson, that the Middle District identified was not intentional discrimination. And in fact, I think
why
when
do
I
you
hear
need intentional discrimination to remedy a problem like the one that I identified?
Because if you're going to use race the way that the Robinson appellants want the court to use race in drawing a second majority minority district, you've got to have a compelling interest.
Thank you.
And
Oh man, I would not want to argue with her.
She's brilliant.
What just happened there? Why is that an important moment in the case?
Well, it's a very important moment in the case, right? It gets to the heart of what this is about. It gets to the heart of how Section 2 works. I mean, Section 2 is not some automatic standard, right? That says, that says groups are automatically awarded congressional seats. Section 2, as it currently works, is governed by a case known as Jingles. And there are 3 prongs that have to be proven, in order to have a claim work. You have to prove, not simply that there are black voters there, but or minority voters there. You have to prove that there is, in fact, a community of voters. You have to prove that they can be represented by a reasonably drawn contiguous district. And you have to prove that there is still a racially polarized voting in place, right? So it's not that this is something that goes on forever. If there was no racially polarized voting, this would stop. These protections would not be called into question. It's the existence of racially polarized voting that makes this a claim. And so while Justice Kavanaugh and many others, right, are looking to put a time limit on this, they're trying to say, how long do we have to do this? We can't believe we're still talking about race in this way, right? Section 2 says how long we have to do it. Section 2 in the Jingles test makes clear this continues until racially polarized voting stops. We don't fix this by declaring it over and erasing the Voting Rights Act. We end this when racially polarized voting ends.
But there isn't a racialized, polarized voting. I don't see it anywhere. It's over. Oh yeah, when did it stop? David, to me, when people talk about race and racism in America, it often you're thinking about black and white. And if you are, to me, kind of the worst thing you can do, I've said this for a long time, and it's not my idea, obviously, but it comes from talking to a lot of black folks and black scholars on the issue, especially, isn't like calling someone a name or doing these kinds of things that these young Republicans were saying in the text message, and these horrible things. The most racist thing you can do is limit opportunity for someone because of the color of their skin. And the most racist of all the racist opportunities you could limit would be the right to vote. Because if you want to advocate for employment opportunities, healthcare opportunities, education opportunities, you would want representatives who would do that for you. But in this country, we have a history of making it as hard as possible for Black people to vote and to be represented in state legislatures. To me, that's the most racist thing you can do, believe, or think, is to limit the votes of a certain type of, in this case, specifically, and especially uniquely American Black voters. That is the end of my TED talk about racism in America.
No, and I think that the clip you just played gets to that, right? I mean, the attorney from Louisiana is saying Black voters in Louisiana want something. They want something that they don't deserve and that they are not entitled to based on their numbers. And Justice Jackson, he's looking at this politically, as far as how many of these districts have to be red, how many have to be blue, and you're asking for more blue than we have to give you. And Justice Jackson is saying, no. Justice Jackson is saying what we're asking for is for our votes to not be intentionally diluted. And there's evidence from the earlier courts that's exactly what's happening in the state of Louisiana. Therefore, the map has to be drawn, right? It doesn't start with how much political power or how many red, how many blue. It starts with, does everybody have a fair chance at winning representation? And when they don't, the Voting Rights Act in Section 2 steps in.
So important for so many reasons. And yet today we're seeing it be walked back. I think one of the most important points to be made about the Voting Rights Act is that it only became controversial in the last decade or so. I think it was like 2006 when Bush was still president, when the Senate has to confirm the Voting Rights Act, every so many years? Was it 10 years?
It had been confirmed in 91, I believe, and then it was up again in 2006.
Right. And so the entire Senate, 99-0, right? All votes to confirm it.
Yeah, it was 98-0 in the Senate. It was nearly unanimous in the House, about 390 to 30 or something, signed into law by George W. Bush.
To say it wasn't controversial, at least in the United States Senate and Republican electeds in the highest levels of America, would be a somewhat fair thing to say. You have written quite a bit about what transpired between then and now, in terms of the Federalist Society and all of the other conservative right-wing movements to, long-term investments to make things, that change things. And I guess the thing that
they made an end run. They did not want to vote this down with an actual vote in Congress. They wanted robed ideologues to do it for them.
Why did they not want to vote it down?
Because people believe in the Voting Rights Act, because the Voting Rights Act remains extraordinarily popular. It is in many ways one of the defining texts of what it is, one of the highest articulations of what multiracial democracy can mean in this country. It's one of, it ought to be considered among the founding documents of our highest ideals.
Yeah, people, I think they say it as like the crown jewel of the civil rights movement.
Yes, right? And so nobody, even Republicans in Congress, did not want to be on record as voting against it or being opposed to it or undermining it. Instead, they put people on the court,
right,
who would do their dirty work for them.
So what the main thing that transpired the time between the vote to confirm it in 99-0 and now is the change over on who is wearing a black robe on the Supreme Court. That's
exactly right.
Bush got to appoint justices, and then Trump got to appoint so many justices as a result of Hillary Clinton losing, as a result of Kamala Harris losing. I mean, and as a result of Mitch McConnell holding up the nomination that Barack Obama made when Scalia died with Merrick Garland, was it? Right?
Yes. Mm-hmm. No, I mean, all of that is 100% correct, right? I mean, at the same time that Congress was reauthorizing the Voting Rights Act, they were conducting the hearings for John Roberts and Sam Alito. This was happening in parallel. And so much of John Roberts' past came out. I've written about it extensively in Anti-Democratic, in that people went back and they dug out John Roberts' memos and records and papers and the op-eds he ghosted back in 81 and 82 when he was fighting against the Voting Rights Act, when his allies were the staunchest segregationists in the U.S. Senate, right? In the end, John Roberts' fight in 1982 even lost Strom Thurmond. And when you've lost Strom Thurmond on a question of race, maybe you ought to look in the mirror and wonder if you've gone too far. John Roberts did not take that tact, right? So all of Roberts's writings, all of his memos, all of his thinking was there to be seen and read. It was covered. He was asked a couple of questions about it. But, he was awarded this lifetime seat anyway. And he has proceeded to slowly erode this, right? There are some people on the court who would go faster. You've got Alito and Thomas who would take the lobster and just throw it into boiling water, regardless of how loud it screams. But with Roberts, the lobster doesn't know it's dead until it's inside the buttered roll, and then it's dinner. He goes slowly, he goes patiently, he goes incrementally. And once you see the pattern, you can't unsee it. And the pattern is pretty clear here. It was set up in the Milligan case from Alabama, and now they're poised and ready to make their big move.
And the big move is underway as we speak. And you mentioned different states, North Carolina. I guess in conclusion, where do we go from here to save democracy? I would imagine one of the most prominent imminent efforts would be in California, where they have Prop 50. So if you're in California, vote yes on that. Barack Obama just cut an ad for it. It looks good, but we can't be sure. What are the other solutions to do whatever we can to fight back that are, that we're in close proximity to, or long-term solutions?
Yeah, there's a lot of various solutions. I don't want to get too far ahead before any of this.
What happened? I lost him. He froze. He's frozen.
Back in 2021 and 2022, it has been the top priority of Democrats in Congress. The For the People Act, the John Lewis Voting Rights Advancement Act. Democrats couldn't get it done because of the anti-democratic nature of the filibuster, right? One more reason why structural problems keep us from having nice things. And so we have to be, but the trouble is that the same structural problems, the gerrymandering, the court's decisions are going to make it that much harder for Democrats to win trifecta power back. So this is going to have to be undone slowly and patiently and over a long period of time. All of these civil rights battles have taken decades to win. Undoing Jim Crow was nearly a century-long fight, right? And in many ways, it feels like we are in for a really long-term fight now. And I think we have to think about it that way and be very patient and very strategic.
David Daley, you are an American treasure. The fact that you know all this and have followed this very, very important issue, published books, essays, columns, and more on it for years is so important. You are one of the best people in the country to talk to about this, and I'm very thankful and grateful that you joined me today on short notice to discuss a pretty scary day, ominous day at the Supreme Court in the midst of a whole bunch of other ominous days. Is there anything else that you want, before I say hang up on you, before we hang up on each other, anything else that you're thinking about, writing about that's, kind of in the news, whether it be this government shutdown or anything else that you're following?
I've got a big cover coming in the New Republic in the next month or so on gerrymandering and how we got here and where this is going. I think what
Frozen again. I'll get him back.
Is not going to be enough to counteract.
You froze on, I think, what?
Sure.
Sorry.
What I think Democrats have to be really real about is to understand that what's happening in California on redistricting might counteract what Texas did, but that there's no way for Democrats to counteract Ohio, Florida, North Carolina, Missouri, Kansas, New Hampshire, Kentucky, and that's going to take, a kill the messenger. And no one likes it when I say this, that the comment threads fill up with, mean things. But the reality is Democrats don't have anywhere else to go on these maps. And there's nothing really that they can do in New York or Illinois or Maryland ahead of the 2026 midterms. So the road is going to have to be through the remaining swing districts. There's 2 in Michigan, there's 2 in Iowa, there's 2 in Arizona, 1 in Wisconsin, a couple in New York, a couple in Virginia. Democrats are going to have to be really, really focused and strategic. The days of sending off a lot of money on Act Blue to whoever's running against Marjorie Taylor Greene or Lauren Boebert, don't do that. Focus on these handful of districts that are going to determine whether or not there's a check on authoritarianism.
Is there a tool or a resource that does the best job and maybe is there any disagreement about where those districts are, like the Cook political map or one of those outlets that identifies them, do you think is most accurate or that you agree with?
I'm sure that Cook has done something on this. I think that University of Virginia, Larry Sabato's outfit, the Center for Politics, has been really, really good on this. There's 15 or 16 swing seats that will not be gerrymandered ahead of this election, and Democrats might have to run the board, and that's going to require the ability to walk and chew gum that our side of the aisle has not always perfected.
Really appreciate you. Good advice as always. Great insights as always. And thank you very much, David Daley, for being here today. I hope folks will go buy your books and follow you on all the social media outlets reading you at the New Republic. And I'm looking forward to that piece. We'll talk about it hopefully when it comes out. And
sure we will. Anytime. Thank you, my friend. Appreciate you. Bye.
Thanks everybody for watching live, and appreciate you watching live. Follow, subscribe, patreon.com/PeteDominic so I get access to and can talk to amazing people like David. I'll talk to you later. Bye, folks.